years in prison. Those were the reasons the state said, we seek punishment of the defendant in this manner. And at the top of their notice of seeking aggravation of punishment, the state indicated in September of 2020 that they intend to introduce evidence of any convictions, juvenile adjudications, and other crimes of the defendant furnished as part of the reciprocal discovery. What the court knows is that there are no other crimes and no other pieces of evidence that support that statutory ground for seeking aggravation of punishment. So in the absence of that sort of evidence, which is the evidence the state indicated back in September it would provide, an absence, as the court knows from the bond hearing and having had those documents provided to it, there is an absence of any criminal history by Greg McMichael, which is a significant factor in your consideration of what sentence to impose. So, without any of the aggravating evidence that was set forth in the notice, the state has told this court now, we wish to simply rely on the facts of the case. And in particular, what Ms. Dunikoski argued is, number one, what she called a pattern of vigilantism. But every example she gave, Your Honor, was not, in fact, vigilantism, gathering up folks who have no authority to do so and taking the law in your own hands. Her examples were notifications that Greg McMichael made to law enforcement about suspicious activity and suspicious people in their neighborhood. And in fact, that is exactly what a neighborhood watch program is all about. That's what Officer Rash testified to you we can't survive without neighbors who will let us know what's going on and provide us the evidence we need to investigate crime. Very different and not at all related to some sort of pattern of vigilantism, which is a violent act. The second fact on which the state said that they were relying, based on the facts of the case, to seek an aggravation of punishment from a life with parole, meaning no consideration for anything less than 30 years, all the way up to life with absolutely no window of opportunity, is that Greg McMichael has shown no remorse or empathy. The difficulty of our adversarial system, a system that is the best system we know of, is that it still leaves no opportunity for an accused to turn and be the person you know he's been for 66 years, and offer condolences to another person for their sadness and for their loss. The other problem with the adversarial system that I know all too well is that an individual who is committed to telling the stories, to explaining to a jury how an individual got where they are right now, often feels like a defense attack on the surviving relatives of this loved one. A vigorous defense often results in the sadness of people who have lost a loved one. But those are the roles that we honorably take on. Our remaining stoic in the face of heartbreaking testimony this morning from people who have lost a loved one is because that's our role in this courtroom. This court has very handily taken care of emotional outbursts to make sure that we're dealing with law and facts and not the kind of thing that can otherwise affect a court or a system that should remain free of those sorts of emotions. So, Your Honor, like Mr. Rubin said, it really isn't anything that I suspect the court will be taking into consideration, the fact that Greg McMichael didn't and couldn't stand up and offer his genuine sadness and condolence for the loss of a loved one, because he's facing other crimes. He's facing charges and trials on other crimes, criminally and civilly. And I hope the court knows that what we need to do to tell his story in any case involving justification, of which there was sufficient evidence to move forward with a request to charge, is that there has to be a clear, palpable, full-throated explanation to a jury about how it is that an individual put himself in a place where our clients felt they had to defend themselves. It must be terribly difficult to hear when it concerns your loved one who's no longer here. And it probably feels cold. But the court knows those are our rules, and it's the only way to make sure that our system operates as it should. So, Your Honor, with no statutory aggravating circumstances, like in a death penalty case, how do you decide? We now know there are no statutory aggravators based on the notice. We now have told you about how the factors that the state said arise out of the trial actually escalate this out of life with parole to life without parole. I suggest to the court that we rely on a wonderful system that the federal United States Sentencing Guidelines set up and the United States Code, and that's you look at two things. You look at the nature and circumstances of the offense, and you look at the history and the characteristics of the defendant. Let's talk, number one, about the nature and circumstance of the offense. The best indicator of what happened in order to respect the jury's verdict is to listen to the jury's verdict. The jury found that Greg McMichael, as a party to the crime, committed felonies that unintentionally led to Ahmaud Arbery's death. After deliberating for over 10 hours, over 2 days, they came back with a unanimous verdict that says, in effect, Greg McMichael did not leave his home that day hoping to kill. He did not view his son firing that shotgun with anything other than fear and sadness. What this jury found is that this was an unintentional act, one that Greg McMichael did not plan, devise, attempt, or seek to have the result that happened. So if life without parole is a sentence that is held for only the worst of the worst, it simply can't be a sentence for a person who never intended that tragic result that took place on February 23rd. If you never wanted another person to die as a result of activities you took part in, you can't be the worst of the worst. Secondly, Your Honor, under 1710(2), the things that this court should consider, you should take in account extenuating or mitigating evidence that you heard in trial. Heard in trial based on the presentation of evidence over several days that Greg McMichael sought to detain Ahmaud Arbery for one reason and one reason only. It was not for sport. It was not for evil. It was for the same reason that the police who repeatedly came to Satilla's shores came there for. It was to get to the bottom of Ahmaud Arbery's nighttime intrusion into Larry English's house. The verdict spoken by this jury, based on their understanding of the law of citizen's arrest, found that Greg McMichael did not possess the information he needed to possess to attempt to execute a citizen's arrest, and that meant that Travis was not in a position to defend himself because he was the initial aggressor, if there was no citizen's arrest that could be supported by the facts and the law. That is the offense that you heard. A reason that is not an evil reason, not a reason of hate, not a reason of anything other than trying to help other people to get to the bottom of this inquiry. Further support of extenuating and mitigating circumstances from the trial you saw in the video itself. As painful as it was to watch, I'm sure the court does recall that when you saw Greg McMichael in the back of the pickup truck, in the bed of the pickup truck, not directing, not doing anything that's going to be the person who's advancing the progression of this from the chase, the attempt to stop and detain Ahmaud Arbery, into what it ultimately became, you most importantly saw that Greg McMichael never even sought to remove his handgun from its holster until after you heard the first shot that took place in front of that pickup truck. So while he's on the phone begging for 911 to come and help, that is the moment he removed his handgun and never fired a shot. That is the nature and the circumstances of the offense that this court heard and upon which the jury reached their verdict. So now, the history and the characteristics of Greg McMichael. Because we know that history is the only reliable measure of a person's character. Greg McMichael is 66 years old. So, Ms. Dunikoski, there has not been just 99 good deeds, but more like thousands and thousands of big and little good acts of kindness, charity, goodwill throughout this man's life. Greg McMichael is a good man. He's not a perfect person. None of us are. But he's lived a good life, a life dedicated to service. And that does count for something. The choices he made as a young man, all the way through the rest of his life, to serve, not to acquire wealth, not to do anything that brought extreme attention to himself, but to quietly go through the business of choosing career options to help other people. You heard at the bond hearing and during the trial of this case, Greg McMichael chose as a young man to serve this country by enlisting in the Navy. And after an honorable discharge, some years later decided to serve his community. Over 30 years in law enforcement. He was not a patrol officer, then later a detective, then later an investigator with the DA's office because he sought power. There was no evidence of anything like that. There were never any complaints about him being aggressive, about him seeking to take matters in his own hands without seeking the appropriate backups. He was not a gun-toting, aggressive officer. His wife testified during the bond hearing. One matter of pride that Greg McMichael always had is that he never had to discharge his weapon during the service of his community. And of course, he wasn't a law enforcement officer or an investigator for the DA's office for money. That's laughable. He did it to help, he did it to serve and protect other people. His post file that the court had into evidence during the bond hearing indicated numbers of commendations and notes from people in the community indicating how grateful they were for his willingness to participate in a case, for his willingness to go the extra mile, for his kindness to families of people who had lost loved ones. Things that are above and beyond the work that he needed to do. Those examples of commitment, of empathy and kindness are further examples of who Greg McMichael is. He is a husband for over 38 years through thick and thin to the woman that he met and married months later. He's a son, a brother, a father, and a devoted grandfather. So yes, that's how I stand before you, Your Honor, representing Greg McMichael, who has now been convicted of murder, and I say without hesitation, he remains a man of goodness. For 66 years, I calculated that's 24,105 days of life on this planet. And we're here, not for a small matter, not as if all of the other erases what happened on that day, but we are here for a driveway decision to pursue Ahmaud Arbery and a 5-minute chase that ended in tragedy. He needs to be punished. But how that contrast between a life of goodwill and service and the bad decisions that were made that day that resulted in a tragedy that the jury said unanimously he never intended could end up in the state seeking the sort of sentence that is devised for the worst of the worst is not consistent. In many courtrooms, Your Honor, that I appear in, right behind the judge, and it might be that way in Chatham County, there is the seal of the state of Georgia. And our Georgia state seal has 3 words on it: wisdom, justice, but most importantly, moderation. Life without parole versus life with the possibility of parole may be nothing more than academic for a 66-year-old man with significant health problems, because it means 30 years, at the very least, in prison. But it is an important distinction. It will affect all sorts of other things that could happen to Greg McMichael while he's in prison. But most significantly, it is the only way, Your Honor, to honor the jury's verdict that Greg McMichael committed crimes for which he never intended the result. For that reason, for the lack of evidence of aggravation, for the presence of significant evidence of extenuation and mitigation, we ask the court to sentence Mr. McMichael to life with the possibility of parole. Thank you.
Thank you, sir. Mr. Goff.
Your Honor, we're going to need a short recess before we proceed. I need to triple check a matter.
Okay.
A 5-minute recess should be sufficient.
All right, well, let's make it realistic. Let's take a 10-minute recess, and then we'll come back on the record at 1:45. Thank you.
All right, so there you have it. The argument by the attorney for Gregory McMichael. Very strong, very passionate, saying that the jury, look at what he was convicted of. He was not convicted of an intentional crime, and therefore that deserves the possibility of parole. Joey Jackson, your thoughts on this as a defense attorney, as she is passionately giving all of the reasons of why there should be a bit of leniency at this point.
Yeah, I certainly, get and understand where she's going. And as a defense attorney, certainly you have the facts that are there. What I don't like or would ever appreciate, and I don't think a court does, is a relitigation of the matter. The jury has concluded what they concluded, notwithstanding what your personal view or agreement or what you urged upon that jury that they rejected. However, having said that, Gene, I think that if you look at what he's convicted of, that is her client, Greg McMichael. If you look at the issue of intent, I think that plays big, right? When it relates to felony murder, you need not have the intention. If a death occurs and there is an underlying felony, like aggravated assault, like the fact that you're either kidnapping or engaged in some conduct to otherwise confine him, false imprisonment, right? Then you have what you have is felony murder. And so certainly the issue of intent is something that is very relevant to the judge. In addition, and finally, the issue about considering her client's life in the spectrum of his now 66 years and all the other things that he may have done, and not measuring it by a snapshot in time. However, that snapshot in time is very significant. I do like the fact that she really related it to these federal rules, and these federal rules of evidence suggest that you look at the nature of the offense and you look at the individual's background, etc., and that's what she did. At the end of the day, though, Gene, let's be clear and real. And you brought up the greatest point of all. Given the fact that he's 66, even if her argument carries the day, even if the judge says, I do agree with you, and that weighs heavily, there was not intent. I agree with you. He has used his life in many other instances for kindness and goodwill. And the judge says, okay, 30 years, 66 plus 30, 96. What real headway did you make? And the realities here are just harsh. The leverage she has is very minimal. And I think, she's darned if she does, darned if she doesn't. Her client is facing a world of hurt momentarily when the judge pronounces his sentence.